All right, there was a remarkable moment in a New York courtroom yesterday as Steve Bannon's attorney, David Schoen, pleaded with a Manhattan judge to relieve him from representing Bannon in his charity fraud case. As you know, that is Bannon facing charges for allegedly defrauding donors who gave money to a nonprofit that said it wanted to build a wall on the southern border. But prosecutors say actually Bannon pocketed the money. He has pleaded not guilty to that, but he may now be without an attorney. David Schoen told the judge yesterday there was a complete breakdown of communication and he can no longer defend Bannon in the case, saying that Bannon and his legal team have, quote, irreconcilable differences. The judge has granted Bannon until February 28th to find a new attorney and reportedly told Schoen that once the lawyer was found, quote, you never need to come back. So joining us now to discuss this remarkable moment that played out is Steve Bannon's attorney, David Schoen, maybe not his attorney for much longer in this case. He was also, we should note, former President Trump's defense lawyer during that second impeachment trial. Good morning, David, and thanks for being here. I guess the first question that I have for you is, when was the last time that you and Steve Bannon spoke?
Well, we speak. We just don't speak about this case. I concluded that we had irreconcilable differences about the approach to the case, the defense of the case, the strategy in the case, the resources for the case. And so the best policy on that was just not to talk about it anymore. And I talked to him through a third-party lawyer. But, I still represent him in the case in D.C., and I certainly speak to him, and we're cordial.
So you still talk to him about other cases, but when it comes to this border wall case that he's facing, you speak through a third-party attorney to talk to Steve Bannon.
Yeah, there's no point any further in discussing the issues surrounding this case. We have very different views of how it should be handled, and when I take on a case, I need to be able to handle it in the way that I see appropriate. Frankly, there was a bit of a breakdown in the D.C. trial. I disagreed with the trial strategy in the case, and so when the trial came, I refused to participate in the examination of witnesses and argument. I just handled the legal issues in that case, even though I had been hired to be the lead lawyer. But I have to be sort of follow what I believe to be the appropriate defense in a case. And a lawyer has to be in sync with the client, frankly, for it to work effectively. And that's part of the rules of professional conduct as well.
You mentioned resources as an issue. And oftentimes when, through my reporting, I've seen relationships like this break down, it's over that. That is part of the issue, lawyers getting paid here. Is that part of the problem here?
No, first of all, if it were, I wouldn't say so, but it's not in this case. When I say resources, I mean the resources surrounding how the case to be prepared, experts, that sort of thing. Very specific approach to the case that I would have counseled to take. But I can't go into those details, of course, as I know you know. And Steve Bannon may well be right, and I might be wrong in how the case should be approached. But it's his case and his life, after all, and he deserves to be able to proceed with the defense that he thinks is appropriate.
The judge seemed to think this was part of a delay tactic, because now Bannon has until the end of February to come up with a new attorney. All of this is going on with the discovery and the evidence. Is this a delay tactic? What would you say to that?
No, it's not a delay tactic. That's where the thing blew up yesterday, frankly. The prosecutor in this case, they investigated the case for 2 years. They had, by their own account, 47 employees working on the case. They told us we set a schedule based on representations they made in September and October. Then in November, they produced a 20-terabyte hard drive, which they produced secretly under a protective order without having ever reviewed it. And, they characterized it as twice the print collection of the Library of Congress. So they asked for a 90-day extension. Yesterday, the prosecutor stood up and said, this is a delay tactic, Judge. We already gave them 90 days. That's when I went emotional, let's say. And I said, Judge, they've just omitted a major fact. They asked for the 90-day extension. And I said, and you know what you told them, Judge, when they asked for it? You said, oh, you need 90 days? You got it. So that's what set the judge off. He called us up to the bench, and he said, something like, I don't approve of this conduct in my courtroom, and you've insinuated I'm unfair. And I said, Judge, let me say, frankly, I think you're unfair. And so then I said, there was no point in dragging us up here. All you had us do was restate what I said in my letters to you. That was the problem going into the hearing. He issued an order saying he needs details showing good cause for the withdrawal. He's just wrong on the law. And when I saw in the newspaper they quoted him as saying I was wrong, he was just mimicking what I said. I said, Judge, you're absolutely wrong about the case. I've litigated right to counsel of choice cases for many, many years in different courts around the country. There's not a lot I know about many issues. That's an issue I've just done a lot of work on, and he wasn't correct on the law. Anyway.
I don't think any judge likes being told that. But David
Right.
Schoen, we now know Bannon has until the end of next month to find a new attorney. We'll see how that search goes. Thank you for joining us on that remarkable showdown in court.
Thank you very much.